All right, so let's get going. I tried to make this presentation as exciting as possible, but it is a lot of legal information. So I hope it's not too boring. I realize it's not a vote of confidence. All right, so today we're going to talk about the New York State abandoned property law for museums. And I just have a quick poll for you. Jason's gonna put the poll together. I hope. There we go. There's a poll. So there's a poll at the bottom of your screen. Just answer. You might have to expand the window size to see all the questions, Jason. But just answer what you think you know. There should be 3 or 4 choices there. Oh, good. So most people have heard of it. That's very exciting. So this, let's wait for a couple more people to chime in with their response. So it's good to know that most people have heard of this law, or at least understand that the topic might be important to your museum or library or archive. And some people have even used the law, so that's very exciting. So let's just go through what we're going to talk about today. The law we're discussing is New York State Education Law 233 AA. And first we're going to review some disclaimers. Then we'll talk a little bit about the history of the law, understand a little bit about what the scope is and who it applies to. Try to understand a little bit about how this law is helpful to you. It can help you resolve old loans and property on your site that does not have a source that you are aware of. And we're going to spend most of our time today walking through the language of the law. I'll help you understand a little bit about how to implement it, and also, of course, how to avoid needing to implement it, because as you'll understand shortly, it is quite time intensive to use the provisions of the law to help you at your museum or library or archive. And we're going to also discuss a few examples. And then we'll have lots of time at the end for questions, I hope. Okay, so first disclaimer, there's me. What we're doing today is really my interpretation of the intention of the law and the letter of the law. If you have questions, please ask for legal advice, because I am not a legal professional and I am not a lawyer, so I cannot help you really. Don't take my advice as the only way to do this, or as legal advice. So please consult a lawyer if you feel you need to do that. Okay, so here's the history of the museum property law. It began as an assembly bill in 2007, sponsored by Assemblyman Brodsky. The Senate version was sponsored by Senator Maltese. It died in the Senate in 2008 and was returned to the Assembly, delivered to the Senate in February 2008, and became a law in April 2008. So it was signed into law in July, and there's one part of the law that refers to things on your site after January 2009, which was sort of the first calendar year of the law being used. So before 233 AA, there was 233A. So 233A is essentially the same law, but it applies only to the New York State Museum. So before this law that we're discussing today, there really was no recourse for museums who were not the New York State Museum to deal with property on their site that was not, for which there was no known claimant or no claimant that could be contacted. So really what it does is take 233A and applies it to other museums operating in the state. All right, so here's the scope of the law. What does this law cover? It covers old loans, and we'll talk a little bit more about this in a second, but the law considers anything on your site where you have a person associated with it, whether that person is alive or dead, doesn't matter, is considered to be a loan. Whether or not you have a loan agreement is irrelevant. If it doesn't belong to you, and you know it belongs to someone else, and you know the name of the person, it's considered a loan. It also covers undocumented property, which is property that has no known claimant. So you have no idea who this belongs to. And it covers doorstep donations, which are things that show up on your site. So you show up for work one day and there's a box of material outside your front door and it doesn't have any identifying information, or somebody has mailed you a box of stuff from one of those, what do I want to call it, like a UPS store or a shipping center. So it doesn't necessarily have a name attached to it. So this is sort of anything that shows up on your site. So what museums are bound by this law? So it applies to all museums operating in New York State, including chartered museums, museums incorporated through other means. So if you were incorporated by an act of the legislature or through some other process of creating a museum in New York. 233AA does not cover New York State Museum, Library, and Archives. This is where 233A applies. And we're not really talking about 233A today. They are very similar, but there are some differences. So how is this law helpful to you? Clear title is key in your collection management. So if you don't own it, you can't do anything with it. Really, you shouldn't exhibit it or send it anywhere. You can't transfer it to someone else. You can't sell it, destroy it, give it away, none of that. If you don't have title, you don't have the right to do anything with the property. So this law provides path to clear title for a couple of different categories of property that might be on your site. This can help you to resolve old loans when the lender has died, or the type of lender who you know they're alive, they're receiving your mail and they are not returning any of your renewal agreements. And you can take care now of doorstep donations within 90 days. So if somebody comes to your gift shop and leaves stuff with the person in the gift shop, refuses to leave their name, refuses to listen to the person in the gift shop who says, please don't leave this here, you now have recourse to retain it for 90 days and then move it along as you see fit. You can also resolve these found in collection items. Found in collection was sort of a procedure or process and really kind of a bad practice I think museums started using in the 70s and 80s. So if there wasn't any known information about the source of some items in your storage area, you could just assign an accession number to the item and list the donor as being found in collection. So that doesn't mean you have title to it, it just means you assigned this sort of placeholder term instead of a donor. All right, so here's another poll. What kind of property does your museum have that falls under the sort of provisions of this law? Jason's going to put up our second poll here. There it is at the bottom. So this poll sort of asks what kind of stuff you have in your collection. And there should be a couple of different choices here. If you scroll down, you can see all the options. There are E choices. Many people have found in collection items. There's also a nice euphemism for found in collection I've seen on some people's labels in gallery exhibits, which is previously unaccessioned. I think that's quite funny because it means the same thing. It just sounds like you're more with it. So some people have the situation where they find things have been left at their site. Some people seem to have situations where lenders will not return loan renewal documents. Some people have all of their collections documented, so that's really great for you. Congratulations. Okay, so it sounds like most people are here because they have found in collection items or just property that is not documented or doesn't have a donor or source. Okay, so it seems like most people have answered, so let's continue on to discuss sort of how we can use this law to help us with found in collections or those situations where lenders will not return your agreement documents. Okay, so we're going to walk through the loan. We're going to walk through the law. In the Files tab over here on the right side, there's a ton of resources I've uploaded for you. So if you want to look at the language of the law, which I have not necessarily included in the presentation, there's two documents. There is New York State Education Law 233 AA full text, and then there is the same document with my annotations on it. And those annotations really are my thoughts or opinions or situations or examples that might help you interpret the law or understand what it means. Okay, so here's an outline of what the law contains. So there's a definition of terms. There's acquisition of property via this law must relate to mission. And we're going to review each of these sections. I just want to show you the full scope of what the law includes. Part 3 says you have to make your collections management policy available. You also have to make it available to people who are bequeathing items to your museum. I'm not sure why 3 and 4 are separate because they cover sort of the same thing. Proceeds derived must be used for acquisition or direct care. Outline of notice by mail and notice by publication. The first few times I read through the law, I was confused about Part 6, and really what Part 6 is doing is explaining separately what these procedures mean when they're used in Parts 7 and 8. Okay, so Part 7 is how to claim abandoned property. Abandoned property is property that has a known claimant, but they haven't come forward. Undocumented property, which is covered in Part 8, is property that you do not know who this belongs to. So there is no known claimant that you are trying to reach. 9 is the provision regarding superseding laws. 10 is property received after January 1, 2009. So that's the doorstep donation portion of the law. 11 is provisions regarding conservation. So if you have something on your site that is undocumented or abandoned and it requires treatment, this portion of the law tells you what to do about that. The lender is responsible for notifying you of ownership or address changes. So this is the one portion of the law that puts some onus on the actual property owner, although there's not a lot of recourse there for you. And Section 13 says that you must keep records of all your transactions in general, and then also keep records of the process for claiming title via the law. And Section 14 says that loan agreements are still valid. Okay, So we're going to review the whole law in more detail, but we're not going to review it in 1 through 14 order because some parts just require a little bit more explanation and attention. So we're going to do the easy stuff first and then the hard stuff later. So first we're going to review the definitions, then there's miscellaneous parts that are just sort of little bits and things here and there. We're going to review in detail what notice by mail and notice by publication procedures mean and what they involve. And then we'll talk about unclaimed property, which is part 7, and undocumented property, which is part 8. I want to spend some time on definitions because the way things are defined in this law are a little bit confusing to me and probably to people who are used to the way certain terminologies are used in the museum field or in archives or libraries, or the way the terms are actually used in other New York State laws with which the definitions here conflict a little bit. All right, so first things first, we're not going to talk about the definitions of conservation measures, deaccession, museum, and person, because those things are generally agreed upon definitions. We are going to talk about what lender and loan means in the context of this law, what property means, what unclaimed property means, and what undocumented property means. All right, so lender and loan. This law assumes that any unclaimed property on your site received before January 1, 2009 is a loan. For me, this was difficult to wrap my head around because everything I learned about loans is that loans have an agreement and the lender agrees to lend and the borrower agrees to accept the loan. In the context of this law, you, the museum, are the borrower, and you do not have to agree to accept the loan. If it's on your property and it's owned by someone, it's a loan. Even if you have some reasons why, even if the lender in this situation indicated some reasons why it was perhaps not a loan. Maybe they left a note that said, I'm giving this to you, or they left it for identification. It's still considered a loan. So anytime loan shows up in this law, it means that the item is considered to be on loan to you. You are borrowing it from the claimant, the person who owns the property. All right, property. In this law is any inanimate object, document, organism, or tangible object under a museum's care which has intrinsic, historic, artistic, scientific, or cultural value. This value word is very interesting because I don't know if the law assumes that everything on our site that is undocumented or unclaimed has value, or if the law applies only to things which have value. I can tell you that many museums have many, many, many piles of undocumented property or found in collection property that is not of historic, artistic, scientific, or cultural value. The law does not speak to that category of material. So if you have broken, unusable property with no provenance that is not interpretable, it would appear that that type of property is not covered by this law. So as you look at your material that's found in collection, consider this value modifier. Claiming property through this law, whether it is undocumented or unclaimed, is not inexpensive. It takes staff time, cash, money to put things in the mail, and it also takes resources to put legal notices in the newspaper, which we will talk about soon. So consider the historic, artistic, scientific, and cultural value of the property that you are interested in claiming through this law before you get going on the process. I do not have an answer for what to do with stuff that is not of value. But we can talk about that in the question section if you would like. All right, so unclaimed property. Property that has a known claimant. This means you know who left the property with you or who owns or owned the property. So that means if Bob Smith gave you something in 1910, this property is unclaimed because Bob Smith, whoever that might be, whether or not you have an address for him or not, whether or not he is still living, doesn't matter. It is unclaimed because it has a name that goes with it. Abandoned property has no known claimant. So this is sort of undocumented property. You have no idea where this came from. This is usually the found in collection material, or items that are not even cataloged or inventoried, or the items that sort of show up on your site. All right, so we've moved on from definitions. We're going to talk about miscellaneous parts of the law. Section 2 means it covers mission-related acquisitions. I'm really unclear personally about the rationale of including this portion in the law. I believe it's supposed to, I think the intention of the section means that if you have undocumented or unclaimed property on your site, that you will not try to acquire property that does not meet your mission. However, in order to remove the property from your site, you need to acquire title or return it to the rightful owner. So I think what this section is saying is that once you have title, you're not going to accession something that doesn't meet your mission. Sections 3 and 4 mean that you will provide potential donors, whether they are living people wishing to bequeath items to you or people who would like to give you something now, you're going to share with them your collection management policy. So most people, most museums make their collection management policy available through your website. You do not have to give people hard copies of your collection management policy if they call you and express interest in donating something to your museum. You can simply say, please review the collection management policy, which is on our website. Proceeds from the sale of anything claimed here should be used for new acquisitions or for direct care of collection. So that means that if you are claiming title to something that is undocumented, or you are claiming title to an old loan, that item then becomes available to process into your collection like anything else that you would be considering for acquisition. If something is on your site and you claim title, that does not mean you have to accession it into your collection. That means you could consider it for acquisition like everything else. If you consider it for acquisition and then choose to decline to acquire it, you can sell that item and use the proceeds either for acquisition or direct care. And if you're interested in learning more about direct care, I've included AAM's direct care white paper from 2016 in the files on the right margin. Section 9 of the law says that if you think something is stolen or is Nazi loot, do not follow this law. Follow appropriate laws related to stolen property. So if you think something is stolen, contact the proper authorities. Do not attempt to find the rightful owner. Section 10, this is the important and fun one. Anything dropped off without documentation at your site after January 1st, 2009, all you have to do is keep it for 90 days. If nobody comes forward, it then belongs to you. So this is stuff mailed to you from a shipping center. This is stuff that you find on your doorstep when you come into work. This is stuff left at your gift shop by somebody who refuses to leave their contact information. So this is great. Before this law, before Section 10 of 233 AA, you sort of had to keep this stuff forever. There was no guidance about what to do with it. Section 11 is the part that deals with conservation. If your documented property is damaged, so if there's something on your site that is a loan that is damaged, you will promptly tell the lender about the damage, and you will not hesitate to conserve it even if the lender does not respond. So in an ideal situation, you would wait for the lender to get back to you, acknowledge that the property has been damaged, and then agree or disagree with your conservation measures. If this is a real loan, all of this would be covered in your loan agreement with the lender. But in the situation where where you're trying to claim the property because of a non-responsive lender, you would simply notify them by mail that some damage has occurred to the property, and you would not hesitate to conserve it even if he doesn't respond, especially in situations where the damage is hazardous to your visitors or hazardous to staff or hazardous to other collections. There's not a lot that of examples I can think of for this, but let's say you have an incredibly large sculpture on exhibit in one of your main galleries and a piece falls off and lands on the ground and shatters. You would want to clean that up, assess the rest of the sculpture to find out if it has weaknesses or needs to be stabilized, and you would not close the gallery to wait for the non-responsive lender. You would just go ahead and proceed with that. This section of the law actually says that you can I'm sorry, I've just lost my train of thought. Okay, so let's say this is a non-responsive lender, and you have just shelled out $10,000 to stabilize this oversized sculpture. You can place a lien on the property so that eventually the lender will have to pay you for that conservation if it was not if the damage was not your fault. And the last one is that the lender is required to tell you if they move or if ownership of the object changes. That, eventually if you had to go to court over some, monetarily valuable loan and the lender moved and didn't tell you and then complained that they didn't ever receive any of your communication, this helps you have a little bit of recourse in not doing all of the work. It also helps if ownership of the object on loan changes, for example, if it's inherited by an heir at the death of the lender that you were not aware of. So this is the record-keeping portion of the law. It was never really codified that museums needed to keep records of transactions, so you were never really required to keep loan agreements or gift agreements or documentation of your collection. And this section of the museum property law says, no, you must do that. And it also indicates that you have to keep documentation of all the processes that you go through within this law to claim title. The last section is that loan agreements are still valid, that this law does not supersede any contracts entered into by museums and owners of objects that would govern the actual lending of an object. So don't use this law as an excuse not to have loan agreements. All right. Notices by mail and publication. This is part 6, so we're going to start going a little bit more in depth into what these things mean. So in order to claim title, you need to document a variety of ways of contacting the known claimant in order to try to get them to take their stuff back or to give you title to it. And you need to do this by U.S. mail. All correspondence is certified and signature required. And this is kind of what this is what these things look like. If you send a piece of mail, certified mail, which is the smaller example here on the left of the slide. Basically what that does is indicate that the piece of mail has been delivered. It's essentially tracking. The signature card is on the left side of the screen. And that allows you to receive essentially a postcard back in the mail with the recipient's signature. And this is really what you need in order to complete the requirements of this law. You need to have a signature saying that somebody received your mail. If you don't receive the card, it means that someone has not received your mail. This is not inexpensive. To send a single certified signature required piece of mail, it costs about $7. All right, so notices by publication. This part of the law asks you to put legal notices in the paper, and it's sort of the county paper of record. So that's you, the museum's paper of record, and then also the paper of record for the lender for unclaimed property if the lender lives in a different county than your museum is located. And we'll go through this in an example. All right. You also need, in some instances, to post notices of this property on the New York State Comptroller's website for unclaimed property. There's a section there that covers museum and military property. The military portion is for metals. There are also, so the Comptroller's form for tangible property and I think I included the instructions from the Comptroller as well about how to list property on their website. And we'll go through how to do that also in an example later. So this is in part 6 of the law, where it explains in detail what notice by mail and notice by publication means. Okay, so now we're getting into the real meat of this law. Part 7 is unclaimed property. Before we even get going, remember this is all not accessioned property of value where you know who the owner is or was, regardless of if you have details about their current address or not. It doesn't matter if you have paperwork. It doesn't matter. Unclaimed property is stuff that has a known claimant. So all unclaimed property is considered a loan, whether there's an agreement or not. All right, so we're going to walk through this example. So we work at this county historical society, and we've discovered a large horse-drawn vehicle in our storage area. It does not have a number, and we've searched high and low for a record. We can't find anything about this vehicle. But there's a note from a former staff member that indicates that John Doe, and with his address, complete address, gave this carriage for an exhibit in 1962. Unfortunately, we don't have a gift agreement or a loan agreement or anything from John Doe saying that he agrees to give this to us or to lend it to us for an extended period of time or for a permanent loan. All we know is that a former staff member believes this thing belongs to John Doe and has provided us with his address. So here's what we would do. All right, let me go back 1 second. For the rest of the presentation, I'm going to be showing you snippets of a really big flowchart that I made to help you use the law to claim title. The flowchart is kind of scary and very complicated looking. So I would encourage you to just not even look at the full thing until the end. I'm going to walk through the parts of the flowchart that apply to unclaimed property and undocumented property and what happens if the lender responds or doesn't respond and what you do next and how long it takes. So if you've opened the document called flowchart, don't run away in horror because we're going to go through it and hopefully it'll seem less scary. All right. So the first question that we ask about anything that is either undocumented or unclaimed or found in collection, or the lender has died, or they won't respond to our repeated requests for loan renewal documents, the first question we ask is whether or not the property owner is known. And in this case, we do know that the property owner is John Doe and we have his address. So even though he lent us this or gave us this carriage in 1968, we're going to send a certified signature required notice of termination of loan to the property owner. So we're going to send this piece of mail to John Doe. This is what the notice of termination of loan looks like. Remember, it's considered a loan if it's on your property. It doesn't matter if it's actually a loan or not. Okay, so the notice of termination of loan, the language for this is in the law, it's in the text of the law. So I just cut this directly out of the text of the law. And you can find this sample letter in a Word document over on the right margin later when you want to use it. So I've just sort of completed this fake notice of termination, including the information that we know for John Doe. So here's what it says. Notice of termination of loan. It says that because the law tells me that the letter has to say this. Dear Mr. Doe, the records of this County Historical Society indicate that you have or may have property on loan. The museum is seeking to determine whether you wish to. We're only giving John Doe two choices here. I'll explain why in a second. The museum's going to give you the property back, or the museum is going to obtain all of your rights to the property and do whatever we want with it. It also asks him to respond in writing about whether within 120 days to tell us if he wants to take option 1 or option 2. So there is also an option 3. The law provides an option 3, which is we can continue this loan with proper documentation. Think really, really, really hard about whether you even want to include let's continue this loan as a choice in the piece of mail you send to John Doe. In most cases, you're not going to want to continue this loan with this non-responsive lender. So don't even put that in there. You're not required to continue it as a loan. So in most cases, you either want to give this thing back or you want to keep it and make sure that you have all of the rights to the property. All right, so we're going to send John Doe this piece of mail asking him to pick 1 or 2 and respond to us in writing within 120 days with his choice. Okay, so we sent this piece of mail. We want to know if the mail was received. So in this run of the example, John Doe received the mail, and we know this because he signed the signature card, which was returned to us by the mailman, indicating that John Doe actually received this piece of mail. All right, let's say John Doe wants us back. So yay! Whoops, wait a minute. All right, so he either is going to want it back, in which case we're going to give it back to him, which is return property, or he doesn't want it, and we're going to claim the title to this property because he will have told us in writing that he wants 1 or 2. So 1 is return property, 2 is give it to the museum. All right, so let's say he receives the letter because he signed the signature card, and then we don't hear from John Doe. We have to wait 180 days. Because he received the first letter, after 180 days, we're going to send him a second letter and find out if he's going to respond or not. Can everybody hear me still? I hear there's a little bit of sound problem being reported. Okay, I just moved myself a little bit closer to the microphone in case that was helpful. All right, so we're sending John Doe a second notice. All right, so we want to find out, let's say, does he respond to the second notice? Yes. If he does, we either, again, we have these two choices. We return the property to John Doe, or he doesn't want it back and we claim title. If he does not respond to the second piece of mail, which he received, this waiting 180 days thing only applies if the guy actually receives the piece of mail. So we wait another 180 days after we receive that return signature card from John Doe. And then, if he doesn't respond after 180 days, we now are able to claim the title to this carriage, and we can either accession it or not into the collection. Okay, so this is the situation for unclaimed property where we know everything there is to know about John Doe as far as his address and his name and where he lives and all that good stuff, and he actually has responded to, he's received the mail we sent certified, signature required. Okay, so what if he doesn't receive the mail? What if we send it to him? Normally when you send a certified signature required piece of mail, the post office will make multiple attempts to deliver the mail over like 30 days. And when you receive this back, if it hasn't been delivered to the recipient, you'll see notes from the post people that says, attempted delivery on, and it'll have 3 or 4 dates listed. All right, so he has not received the property, or he has not received the piece of mail. Okay, so you are going to then post a legal notice in your county's newspaper and John Doe's county newspaper, because we live in this county and John Doe lives in neighbor county, or lived in neighbor county, so we are posting 2 legal notices in the paper. The notice has to be up for 3 weeks. Then, after the 3 weeks is done, we are going to we have to wait 180 days. Then, after that, so we've sent him some mail, nobody received the mail. We've posted notices in the newspaper or newspapers, and we have waited 30 days and we have waited 180 days. Then, we are going to post the property on the New York State Comptroller's website for 180 days. The posting remains up for 180 days. At the end of the posting period of 180 days, we then wait 30 more days. If no one comes forward, we can claim title to this carriage. We have waited a total of 420 days. That is more than 1 year to claim title to this carriage. It's a long time. Okay. This is what the legal notice looks like. Again, this language here is taken directly out of the law. I've also included it in the margin. Notice of intent to acquire property. This County Historical Society hereby asserts its intent to acquire title to the following property. You need to describe the property in some way. However, legal notices are normally by word. That's how they charge you. So you may want to describe it briefly. And then the rest of the legal notice goes on to say, if you claim ownership of this property, you must contact the museum, blah, blah, blah. You may want to gang these together. So if you are doing unclaimed property as a project, 90% of the words in this notice of intent to acquire property legal posting are repetitive. So for every single item, if you listed them individually, you'd be paying to say essentially the same thing for each individual item. So you can gang them all together. So if you had a carriage 1880 and a painting and a set of books and, I don't know, a dining room set, you can put them all in the same notice. Okay, so that's the end of unclaimed property. So that's the end of the part where you know somebody, living or dead, who owned or once owned this property. You have their address, and you send them the mail, and then they respond or don't respond. So you know enough information about the property to contact somebody who is who's an owner of the property. All right. I see that there's a couple questions in the margin, so I'll see if I can answer a couple of them. Is there a better option than the newspaper? All right, wait a minute. Let me scroll back up. If the property owner violated the terms of their loan, but then responds to the notice and wants the loan returned, who is responsible for paying the cost of the return shipping? I would say that the cost, I would say it depends on the cost of the return shipping. Is getting this person out of your hair worth a lot to you? Then just pay the cost of the return shipping. If the return shipping is beyond your budget, let's say it's $2,000 to get this item back to the lender, then you could take them to small claims court. But because it's ultimately going to be a small sum of money, the amount of legal costs to get the shipping out of the lender is probably going to cost more to get the shipping out of the lender than the shipping actually costs, if that makes sense. What due diligence is required on an old address? What effort are considered reasonable? That's a really good question because it's a time and money question. If you can find an address for a person, it is less time and resource intensive to send a piece of mail than to go through the additional cost and waiting period of the notice in the newspaper and the comptroller's website posting. So I would recommend doing some work to find an address for a person. If you're pretty sure that the person is deceased, I would probably then move forward with the newspaper posting on the comptroller's website. Sometimes getting into who is the executor of the estate, who are the legal heirs of the estate, is a little bit more problematic and probably beyond the scope of what would be expected of you as far as this law is concerned. Is there a better option than a newspaper? People rarely read newspapers. So the legal notice is used for everything. If you open your newspaper classified ad, there are legal notices for forming limited liability corporations, for foreclosed properties, for all kinds of different things. If you really want to find the owner of this property, you might work with your local newspaper on a little PR campaign and do a story about how the museum is attempting to find the rightful owners of this property. There's two ways of approaching that. One is, it's great, the museum's going to figure out who this stuff belongs to, or the museum does a really bad job at being a museum and they have a bunch of stuff that they don't know where it came from. What are they doing over there? This isn't very professional. So consider carefully how you choose to do that. And the last question over here is, what's the best way to document each of the steps? So I would recommend keeping a big spreadsheet of the parts, the steps that are required and what happens at each step, so that you're sort of, for each item, you're tracking. And then for each item, I would have a folder Or if you're going by lender, so if you have an old loan that has 50 items, I would make a folder for the lender because you're going to have one communication to the lender for all 50 items. You don't have to do this for individual items. So it depends on how you're approaching it, but just keep every single piece of documentation. Okay, so let's move on to undocumented property. So this is your found in collection, and I don't know where it came from. There's no known claimant for this property. Okay, so this is all property of value that you have absolutely no ownership information about. This includes found in collection, previously unaccessioned, donor unknown, stuff that's just hanging around. We've all got stuff that's just hanging around. And just a reminder again, all undocumented property is considered a loan per this law, even though you don't know who the owner is. All right, so here's our example of undocumented property. This county historical society discovers a painting that has found in collection listed in the donor field. It was assigned number 1982.1978, or I'm sorry, 1982.78. We know this painting is European, so it does not meet this county historical society's geographic scope. We would like to deaccession it. So in this example, we've presumably had this painting since 1982, since that's what the front part of the accession number tells us. And we know that it's European, and we don't want it in our collection. In order to deaccession this, in order to remove this from our site, we need to claim title to it. I know that somebody way back in the beginning asked a question about somebody gave the museum something to which the donor did not have title. So in order to move something along from your collection, you need to have the right to sell it, and that's where the title piece comes in. All right, so we're back at the beginning. The first question we ask is whether or not the property owner is known. And in the case of this painting, we do not know who owned the property. Was this property received before 1/1/2009? Yes, because we have that 1982 accession number. All right. Is the property recorded as found in collection or otherwise documented? Yes, because we have an accession number, we have some kind of database record, maybe this painting has a file. We know it's been around since 1982. And that's really what this documentation question is asking. Has this property been on your site for more than 10 years? Well, we know it's been here since 1982, and it's well after 1992, so yes, it's been on our site for more than 10 years. All right, so what's the next step? The next step is to post a legal notice in your county's newspaper. Because we are the person who, the entity that's been taking care of this item since 1982, and we do not know of any claimant, we only need to post one legal notice. So this is the same procedure from the unclaimed property portion, except we know we only need to post it in one newspaper because there is no known claimant that we also are trying to get in touch with. All right, so we're doing this. We have 30 days of newspaper posting. We have to wait 180 days after the last notice is posted. Then we're going to post it on the New York State Comptroller's website for 30 days, for 180 days. We're going to wait for 30 days, then we're going to claim the title. The total wait portion is 420 days. Okay, so let's change a little bit of the situation for this same painting. Let's say this painting was left at the front desk by somebody who refused to give their name or was mailed to us anonymously. We received the painting in December 2017. So back to our flowchart. Is the property owner known? No. Was the property received before 1/1/2009. No, we received it in 2017. So if we've received it in 2017, we're going to document having received the item. We're going to wait 90 days and we're going to claim title if no one comes forward. So to document the receipt of an unclaimed or an undocumented property item, you can keep if it was mailed to you, keep the box it came in, which has sort of a ship date or a receive date. You can also send, you can make a memo to file. You can make just some sort of official internal notation. If there was somebody at the kiosk who received it, you can just state, kiosk worker Jane Smith received this painting from an unknown depositor at time, date, have her sign it, put it in the file. If nobody comes forward after 90 days, you can then claim the title. It's certainly possible that someone will call and say, I dropped off a painting at your kiosk, how come no one ever sent me a gift agreement? And that would be nice. But if no one responds, then you can claim title. At the very end, if I don't remember, somebody remind me about what to do after the claim title step. All right, so a couple more changes to our painting example. Okay, this painting was found in a storage area last week. Nobody knows anything about it, but we know the painting's been hanging around for a really long time. Previous staff members, when asked, say, oh, that thing, nobody knows anything about it. So what do we do in this situation? So we already have established that we do not know where the owner of this painting. Is the property recorded as found in collection or otherwise documented? It is not. It's just hanging out in the storage area. Everyone seems to know that it's been here for a long time, but there's no documentation of that. So the next step is to document the property with a description and an inventory number. Do not give the property an accession number. You don't own it, so you can't accession it. No, we don't know who has title to this, so no one has the authority to give it to the museum, and the museum cannot accept it if it doesn't have an owner willing to relinquish the title. Hopefully that makes sense. So what you want to do is document the property with some kind of number that allows you to keep track of the item while it's on your site, while you're going through this whole process, but you don't want to pretend like you're accessioning it. You want to give it some kind of other sort of number, an inventory number. At Farmers Museum, we gave things an NN number, which is a no number number. So there's just the prefix NN with some number after it. You can put them in your database, you can put it in a separate spreadsheet, however you want to do it. Just keep track of it. Record what you know about the item just for future use. Take pictures. That's sort of what's included in documenting the property. Although that's not specified in the law, that's just kind of common sense about how you would document anything that's in your collection. You don't have to fully catalog it. Just make sure that there's no way of confusing it with another undocumented painting in your collection. All right. So we're going to document the property. Then we have to wait 10 years from the initial documentation. So in order to avoid using this law, document stuff on your site that you don't know about, that you don't have any information about, because you will cut down on the amount of time you're waiting. All right, so after we wait 10 years, then we post a legal notice in the county's newspaper. We wait 180 days. Then we post the information on the New York State Comptroller's website. So you will have waited 11 years and 55 days to claim title to this undocumented item in your collection. That is a long time. Okay, so that is the end of the sort of presentation here. Congratulations for paying attention. I'm sorry if you have taken a little snooze in the middle. It is not the most exciting content, but it is really helpful. So just so you are aware, this is what the big flowchart is that I created to help you process your property. So it starts at the top with, is the property owner known? And it goes through all of the other steps of what you do if the property owner is known or unknown. And you can download that from the right margin. So after you claim title to the property, you should treat it like any other potential acquisition. Just because you've had it for this long does not mean that it is part of your collection. So I would really encourage you to put it through whatever process in your collection management policy any other new acquisition goes through. So once you've claimed title to it, even if it's been on your site for 50 years, treat it like a new acquisition. Decide using the same criteria as everything else if you want to add it to your collection or not. If you do not want to add it to your collection, you can use any of the disposal options available to you in your collection management policy, such as transferring it to another organization, selling it through open or sealed bid at a public auction, however you would like to do it. If you derive proceeds from the sale of any of these materials, the law specifies that you should use them for direct care or for acquisition. And AAM has the lovely white paper that specifies what direct care means. So, I would love to answer questions. Go ahead and type them in the box and I'll try to address everybody's questions. Okay, so Kelsey has asked, what about pieces we've had for over 100 years when there's no record of a lender other than Mrs. Thomas or something else very generic? We've been holding the piece for 100 years, waiting another 500 days seems punishing. Yes, so the question is, do you have any documentation about this item, or has it just been sitting around? I mean, documentation can include pictures of the thing on site from 1955 at a fundraising event. You don't have to. You just need some proof that it's been around for as long as it has. Whatever that proof is open to debate. I mean, use your judgment. Okay, so Judith asks about, what about objects with value less than $50? Well, the law specifies, actually, let me say, the law does not mention or consider monetary value. It does mention and consider intrinsic, cultural, artistic, or some other types of value. So essentially what it's saying is value is subjective. I would recommend that if you are considering processing something through this law in order to claim title, that you may have a portion of your regular committee meetings or some type of internal memo or deciding process that would, in some kind of group way, determine whether or not something is of sufficient value to require that it be handled under this law. The law does not say anything about what to do with items that have no value. And by value, I mean cultural, historic, artistic value. I don't have any real recommendation about what to do of items with items that have no value. Perhaps what you would want to do is document what you're doing with it. Document what it is, document the decision that it does not have sufficient value in order for this law to apply to it, and then perhaps dispose of it through any of the disposal options already available to you in your collection management policy. And I have to be honest, I really didn't pay a lot of attention to the value clause in the property definition the first few times I went through this. The value thing really stood out to me when I was preparing this webinar. So I haven't spent a lot of time talking, thinking about what to do, and I don't have any experience dealing with something that does not have value. All right, Donna asks if, do you include the lender's name in the newspaper legal notice or just the object description? I would say that although the law does not specify, if you know the lender's name, I would include it in the legal notice because you have a greater chance of someone coming forward who knows something about it. If you have a communication in writing giving material, why is it still considered a loan? So if you have communication in writing that it indicates the intention of the donor, then it is not considered a loan and you actually don't need to process it through this law to claim title. So in order to complete a gift to the museum, we use the 2 out of 3 rule. So you need to know the intention of the donor, you need to have possession of the item, and you need to have a deed of gift. So if you have 2 out of those 3, that's generally sufficient to claim title. So if you have a letter from somebody saying, I, John Doe, give you this carriage, and you have the carriage, that is sufficient. You don't need a deed of gift. If you have a deed of gift and you have the thing, you don't need any intention. If you have a deed of gift and you have intention, but you do not have the object, you can go get the object, but the deed of gift and the intention is sufficient to claim title to the item. All right, if you have, okay, Kelsey asks, why can't we post it on the comptroller's website at the same time as we put it in the newspaper? Again, waiting 420 days is so hard on a small museum. Yes, 420 days is really hard, and I don't know why you can't do all those things at the same time. I do know that this law is very similar to abandoned or unclaimed property laws in most other states. So this long waiting period is it's common. That doesn't mean it's right or doable. It just means that it's common. All right. Kathleen asks, can I clarify what type of institutions this law applies to? Specifically, does it apply to small nonprofit archives? I think you said up front that it does not, but I've read that I understood. Yes. So this law applies to basically any nonprofit organization that has a collection. If you have a collection, this law applies to you. If you are a privately owned museum, the law does not apply. If you are a New York State entity, so if you are the State Museum, Archives, Library, SHPO, New York State Historic Site, any of that, the law does not apply to you. 233A applies to you. All right, can I review the different circumstances where we would need to wait 10 years to acquire title? All right, you need to wait 10 years from documentation before you start the process of acquiring title. So what documentation means is not specified. You can have any different types of ways of documenting. If you exhibited something in 1972 and you have, some type of exhibit record, even though you don't have any information about the object, that counts as it being on your site for that long of a time. So you don't have to do your best. I mean, I think that's all laws are open to interpretation. That's why laws go to court, and so that the court can interpret the law. Also, weigh the risk of the time and cost that it's going to take to use the provisions of the law with what your organization will get out of it. Before this law, there wasn't anything. Essentially, if something was on your property and you didn't want it and you moved it along, and someone later came forward and said, hey, where's my thing? There was no law protecting you. Also, I did not specify that if someone comes forward to claim an item, the burden is always on the claimant. So they have to have some kind of proof that the item belongs to them or that they should be considered the legal owner. You can be satisfied with their proof if you would like. But they need to come forward and say, here's some written documentation that this belongs to me. Will we be able to see this recording later? Yes, this webinar is recorded. What about drop-offs for items given to be sold? So if something is given to be sold, I would recommend that you develop some type of a documentation form that would allow the donor to specify that intention. And also make clear that if you're the tiny town historical society and somebody drops off to you, the inaugural suit of tiny town's first mayor and says, sell this at your next fundraiser, that does not mesh with your mission. So if people are giving you things to be sold specifically in order to raise money, that's fantastic. But make sure that they're clearly outside of the gray area of whether or not you should actually be collecting them and not selling them. So anyway, have some type of form that allows the donor to indicate their intention. So, we call that a temporary deposit form. So usually what that says is it provides a space for the donor to indicate all of their contact information. Has a checkbox for why they are leaving it here. It can be for research, for consideration for acquisition, or as an unconditional gift. And then if it's for acquisition and the collections committee or whoever decides on acquisitions doesn't want it, the lender, donor, depositor can specify what they want you to do with it if it's rejected for the reason they're leaving it there. So if they're offering it for acquisition and you don't want it, have a checkbox that says you can sell this. So objects that were donated to be sold for direct care, absolutely. Again, this is just with the documentation issue. You want to make sure that you have the intention of the donor documented somewhere, that the intention goes with the item that they're depositing, and that it does not conflict. To sell something for direct care should never conflict with your ability to meet your mission. So if somebody's dropping off something to you that could even be considered by a passing person to be, hey, why is the museum selling all of this stuff that seems old and important? You want to make sure that it really, it may be old and important, but it's not related to your mission. So if you have documentation of objects that were donated specifically to be sold for direct care, and you have some, indication that's why they're there, then you don't need to wait. You don't need to process them through abandoned property to claim title. If they were given to you for this reason, you don't need to process them through this law. Jennifer asks, recommended methodology of administratively earmarking proceeds to a separate fund to designate the stipulation for a specific use. So most museums will have a restricted fund for acquisition. If you do not have a restricted fund for acquisition, it's a good idea to set one up. Or if you're using them for direct care, proceeds for direct care, you can just put it back into your operating budget, but specify in sort of, a year-end statement, this $150 proceeds received from such and such a sale of an abandoned item were used to purchase $150 of boxes to, rehouse parts of our textile collection or something. Just document it. Okay, so Martina says, what about documents and photographs from another institution that failed and went into bankruptcy? My museum got objects documented this way via court. What rights the donors of the original institution have? That's a great question. If most gifts to museums are considered to be unconditional unless the donor specified a condition. So unless you have documentation of a specific condition from the original donor to the museum that failed, all of the rights were owned then by the failed museum, and if all of those items were transferred to you, they were transferred with their rights, so you now have all the rights. So if a donor of an item to a museum that no longer exists comes forward and says, that's my item, then you can just explain to them that the collections of the failed organization were transferred in whole to your museum, and you now own all of those things. They don't need to sign new gift agreements. The court documents are all that you need in order to know that you have title to that material. So, are there any other questions? I hope this was helpful. I gave you a lot of information. There's a lot of backup documents over in the margin that you can download. The webinar is available later from DHPSNY, so please, you can review it if you would like. If you have questions, you can send them to me if you would like. I'm going to stick my email down in the chat box. If you would like to send me an email, you can. I may or may not be able to answer your question. I may have to refer you to sort of legal counsel. This is where it's very helpful to have a lawyer on your board. If you have a lawyer on your board, you can share with them all of the documents from this webinar, talk to them about how to proceed in certain situations. That's why they're there, to help you with this kind of stuff. So hopefully we're all going to get rid of those found in collection records, because you will have claimed title through New York State's abandoned property law for museums. Yes, a legal department in your municipality is really helpful. So I'll hang out here and wait for any last minute questions, but I think that's going to be the end of our webinar for today. And have a wonderful afternoon, everybody.